Now, we continue answering the 3 questions not answered yet. To answer question number 5, you have to look into whether the notarial certificate has all the details. Rule 8, Section 2 of the 2004 rules, it says, the notarial certificate shall include the following. A. The name of the notary public as exactly in the commission. B. The serial number of the commission of the notary public. C. The words notary public and the province or city where the notary public is commissioned, the expiration date of the commission, the office address of the notary public, and D. The roll of attorney's number, the professional tax receipt number, and the place and date of issuance thereof, and the IBP membership number. You must not forget also the MCLE compliance number. It usually looks like this. This only covers the stamp of the notary public. Aside from the fact that the notary public must seal the document by plainly stamping in this area of the document, then the notary public must indicate the document number, the page number, book number, and series number on the document itself. And this is in consonance with the notarial register entries. Therefore, you cannot have these items completed without the entries in the notarial register. To give you a clear picture of this, we are showing a video in case one is notarizing an affidavit. Quickly, I'm going to teach you how notarization is done and especially what should you do in the notarial register. So this is your official notarial register or the notarial book. I bought this before the OCC of Lapu-Lapu City and I was given an official receipt. Now, that official receipt is very important for your page 1 of the notarial register. Here, when we submit as notaries public, we have to comply, and when we submit this notarial book to the office of the clerk of court of the regional trial court, we have to indicate the official receipt and my name and my address. Now, hypothetically, we're trying to notarize an affidavit of Juan de la Cruz. Now, the affidavit would be entered. You have to write here affidavit and here as your entry number 1 because this is your first document being notarized. The name of the party would be, if you look at the affidavit, it's Juan de la Cruz and his address is in Posoc, Lapu-Lapu City. Then the names and addresses of witnesses, there's none, so not applicable or none. Then the competent proof of identity here would be the tax identification number, and the time and date of notarization would be as found in the affidavit, April 20, 2020. Then the type of notarial act, this is a jurat, like as simple as that. The fees, let's say 500 pesos for this affidavit, since there's a prescribed fee for this. And what if Juan is a person deprived of liberty? So we can indicate here that the notarization was done before the city jail. Now, this is a very important area of the document because this would serve as your area where the notarial or the notarial certificate, and this is also where the seal should be placed. And this is my stamp. For purposes of my safety, I'm not showing because this is my official notarial stamp. So here, if you can see this is a this is my supposed signature, so it must be signed also. Then the seal would be placed here in this area, so you can do the sealing. Now, the document number is also your entry number, so if you remember, it's number 1, and your page number is found here and found in a notarial certificate here. And since this is my book, 4th book, then I wrote in Roman numeral number 4. So what if there are multiple copies of this affidavit? What happens? It's still doc number 1, and you don't need to enter the other copy here in the notarial register. And don't forget, Juan must sign this area on top of his name. And you have to remember that before leaving the office or before finishing, if you're assisting a client or you're working in a law firm, you have to remember that this area must be completed. Okay? Thank you so much. And last, the notary public must sign. So, these items must be found in the document. Absence of one makes the notarization incomplete, and the document would not be accepted by the office or person that required the same. Thus, you must also look into this. Now, what are the things that the notary public cannot do? This is in answer to question number 6. 1. If she or he is not commissioned in the place of notarization, then he or she should not notarize. 2. Even if he is commissioned, but if the commission has expired, upon expiry, the notary public could no longer notarize. As previously said, the notarial certificate contains the expiration date of the commission. 3. A notary public cannot notarize outside of his regular place of work or business. Exception for such situations is that she is allowed in accordance with Rule 4, Section 2, 2004, Rules on Notarial Practice. 1. Public offices, convention halls, and similar places where oaths of office may be administered. 2. Public function areas in hotels and similar places for the signing of instruments or documents requiring notarization. 3. Hospitals and other medical institutions where a party to an instrument or document is confined for treatment. And 4. A place where a party to an instrument or document requiring notarization is under detention. Remember that the exception presupposes that the parties requested this, but the place of notarization is still within the notary public's territorial jurisdiction. Aside from this, the same provision prohibits the notary public from performing the notarial act if the person involved is a signatory to the instrument or document. A. Is not in the notary's presence personally at the time of the notarization. B. Is not personally known to the notary public or otherwise identified by the notary public through competent evidence of identity. And one very important disqualification is under Rule 4, Section 3, which says that a notary public cannot perform the notarial act if A. He is a party to the instrument or document that is to be notarized. B. Will receive as a direct or indirect result any commission, fee, advantage, right, title, interest, cash, property, or other consideration except as provided by these rules and by law. Or C. Is a spouse, common law partner, ancestor, descendant, or relative by affinity or consanguinity of the principal within the fourth civil degree. So basically, as an example, I cannot notarize the documents involving my cousins or the nieces and nephews of my parents. To answer question number 7, I'm going to give you just 3 safeguards based on my experience as notary public. 1. You have to make sure that the notary public has the authority to notarize and within his or her notarial jurisdiction. 2. Make sure that the items needed showing the completeness of the notarization are found in the document itself and that the document has been entered in the notarial register. 3. Before you go out of the notary public's office, you have to read the document itself. You can always ask the notary public that even before doing the notarization, you can read and check the document yourself. And if there are things that you do not understand, do not doubt to ask for clarification or explanation. We hope you learned so much from this lesson and you will apply this not just in your study of law, if you are a law student, but even if you're not a law student, in your own personal circumstances, in case you need the assistance of a notary public, you will take note of these. Thank you so much. See you in the next lesson.